65, and then pages 70 to 72. Those pictures. I'm so that everybody knows I'm going to ask. I just need some clarification as to what I'm seeing. Okay.
Okay.
That makes sense.
Hello, Council. Welcome to the March 12th, 10 a.m. docket of the Kansas Court of Appeals. I am Judge J.C. Hurst, and I am your presiding judge today, which means that I have the pleasure of attempting to call this case with the names in it, and also of keeping your time. So we will go ahead and call the only case on our docket this morning, case 127335. It appears to be appellant's Purchase. Is that how you say it?
Purchase.
Purchase. Oh, I was right before. Hill had me go astray. Purchase, Picard, and the Board of Kansas Commissioner of Logan County versus Dirks and Dirks. And we have an appeal and cross appeal here, it appears. So appellant and cross appellees, could you state your appearance for the record? Counsel for appellants and cross appellee.
What was that, Your Honor?
Could you state your appearance for the record?
Charles Peckham of Brown Creighton Peckham, Atwood, Kansas, appearing on behalf of Mr. Purchase.
Thank you.
Your Honors, the appellees and cross appellants Dirks appear through counsel Todd Stramel, Colby, Kansas.
Thank you, counsel. Mr. Peckham, would you like to reserve, we give 15 minutes time for each side. Would you like to reserve time for rebuttal?
4 minutes, Your Honor.
So observed. I would like to introduce the other members of the panel, which I neglected to do earlier. My apologies. The dignified Judge Hill is here with us today. Illustrious judge. And Judge Arnold Berger is also here, the gorgeous and glowing and ever ready to ask you lots of questions about your exhibit. So, Counsel Peckham, we are ready for your arguments. You have 11 minutes by my count.
Thank you, Your Honor. Basically, this was decided on the basis of an easement by prescription case, and basically this is a situation where a new buyer came into the picture in 2022 and decided to try to take more control of the property of my client to the east of her. She had a rather small lot. In the exhibits, there is the survey of the lot that she bought. And so the end result was this case here. The basic facts of it are my client owns a junkyard, has it fenced, and he and the predecessor of the plaintiffs were pretty much neighbors from about 1994 on. Well, as owners, Miss Morris had rented the property, I believe, starting about 81 from the co-op, where she was resigning to did not own. And there's some disputed testimony. Basically, the testimony was that he had given her permission to take care of the yard and also go up the west side of his property to the garage, and access to both properties was coming off what was front PC, which turned out, and during the course of this case, to be actually owned by the railroad. And that was a satisfactory resolution until 2022, when it was purchased from the Morris estate, and this the Dirks took over and tried to exert more control over the property.
Counsel, I've got a question for you.
Yes, sir.
It seems to me, when I read what the judge said about this, he was impressed that this easement was established well before your client came onto the scene. Is that correct? And do you find that reasoning faulty? And please explain why.
Yes, Your Honor. Basically, the land was owned by the co-op from about 1974 on. This would be the house of the Morris property. There was nobody who testified about the co-op or any owner of the property testified. Mr. Keller, who had sold the land to my client, was also not available as he was deceased. The only testimony was by Linda Ayers, who had resided in the rental house that is now the Morris, well, the Dirks property, but she was a tenant. She thought that the co-op owned the property, but that was the thought. And there were, I believe, some testimony about some grain bins on the property, which were owned by the co-op, which were bought by one of the people testifying. But there's really was no testimony as to how the land was used, how things were accessed. And I didn't find a Kansas case specifically on whether or not a tenant can basically maintain adverse prescription or adverse possession.
But the question was, the judge found that the easement existed well before your client bought his property. Is that correct? Or am I misreading what the judge stated?
No, you're not misreading what the judge said. It is our position that the evidence was not, certainly not clear or convincing. In fact, there wasn't much really of what occurred prior to Ms. Morris having the property and my client acquiring it. It was owned by the co-op for a considerable period of time, which included the house, but there wasn't a lot of testimony as to how it was used. There was kids right across it. There was some playground equipment on it and a couple of grain bins, but as to the access to and from the house, there was not a lot of testimony on that until we get to the time period of Morris and purchase.
So you're saying your argument is that there is no evidence to support the findings of the court?
There's not substantial evidence, Your Honor, would be our position.
Have any evidence to the contrary?
The evidence to the contrary is, again, rather slim. If you look at our exhibits, which had some excerpts from the state highway maps, they had a blow up at Page City, and they do indicate that Front Street, Front PC did extend up to the Morris property. And there is, Mr. Straw made a point to draw about the garage being close to the edge. It's like 19.1 feet from the edge of the property, so it's accessible, or at least the testimony witnesses indicated that it would have been accessible by going up the property of Morris. That there was.
So that was one of the questions I had. I think I told you I was going to refer to a couple exhibits here. I think they're exhibits from the plaintiff's case, petition, but volume 1, page 65 is showing, I think, what you're talking about, extending that street. You've got in yellow on that picture an extension down to First PC going, I don't know what direction, if we're properly north, south, east, and west, but is that what you're talking about? You're saying that the county, that is designated as a county roadway. It just hasn't been cleared out as such, or?
It was a road that was used. It was on the state of Kansas highway map, but it was never physically designated as such. And the testimony in the trial indicated it was not officially a road. That township.
Right, because there's nothing there. I mean, it doesn't look
Right.
like there's a road there, right?
Yeah, it's basically a trail road.
Uh-huh. And
Yeah.
so is your position that that would be the public access to the property?
It was the access used by the public because it also was the access used by my client, Furchess, and his predecessor, Mr. Kelly, to the area that's the salvage yard.
Even though there's no road there?
There's not an official road. It is a trail that is used as a road, but it's not been one recognized officially by the township. But
Well, it doesn't look like a road at all on the picture. But,
well,
okay,
some of our
so
roads in Western Kansas aren't too good, Your Honor.
okay, so the other picture, if you don't mind, I'd like to look at is volume one, page 72. And so that's showing the outline of the property. And I'm assuming this place right in front of the plaintiff's home that's the loop road we're talking about. Is that right? That's the loop.
Yeah, that is the loop that the plaintiff attorney referred to, which is in between the salvage yard and the home, but is, on
So
my.
are you saying that your client wants to extend the salvage yard all the way over to his property line right in front of the plaintiff's house?
Your Honor, the background of the case is that after Mrs. Morris died, he had extended his road, the fence out of his salvage yard since he needed additional space, but he did not go all the way to the property line of.
So how did he block off? Because I mean, what I'm looking at shows the loop is still there and accessible. Did he cut off that loop at some point, or is just a threaten to cut off the loop?
Well, he would have reduced the space between the house and the salvage yard's wall as he moved it west, but there was still.
So he would do away with the loop. It would just be
part of it. Loop,
straight
yes.
in and straight out. Okay. All right. Thank you.
And I want to clarify, that's sort of my clarifying question as to what it is your client wants. Your client isn't saying access should be that yellow county road from page 65, right? Your client is saying that it should just be a lesser amount of this loop.
Basically, Your Honor, there's at least, I believe, from the overlay, which is in the exhibits, there's about 15 feet from the front of her house to the property line. He said in testimony, he would not have a problem giving her Morris, an easement for 30 feet from the property line. His fence would not go beyond that. And
Could she use her garage then with that sort of gift?
Your Honor, the garage is 19.1 feet from the property line, according to the overlay measurements. And with additional 30 feet, it certainly would be enough. Several of the witnesses talked about basically 90-degree turns. You turn into someplace, back up, and go back out. Said that an ambulance could do that without having to use the loop and so on. So,
How about the school bus? There was some talk about the school bus. Could the school bus do that?
A school bus would have to go in and then go out.
Back out, right?
Well, why couldn't the testimony about the school bus was a little confusing to me. I'm not used to it coming right up to the house. It doesn't just sort of stop at the corner there.
It went into the house because I believe that was a dead end situation. So it would need to turn around to go back out. It was not going to go on further to pick up any more kids. It was, go in there, pick up the kid or kids there, then back out.
I
Or
see.
turn around and go out.
I'm sorry, we have taken up a few of your minutes of questions. So I'll let you have reached the end of your time, but I'll let you take a minute or so to wrap up, unless my colleagues have any other questions. Judge Arnoldberger, yeah, go ahead.
Okay, I do have one other question, and that is back to those exhibits, page 70, which shows this red line around the junkyard. What is that? What's that supposed to be indicating? I don't understand what that red line indicates.
I believe this is again place that just basically indicate the area that the plaintiff was claiming should be included in property she could access.
Okay, all right. I'm sorry. I probably should have. I'll ask that to Mr. Strand, I think.
Okay. Basically, what we're asking is that we believe that under the case law of Kansas, that the requirements for an easement were by prescription were not met. And so we are requesting that the judgment of the district court be overturned and that Mr. Furches be allowed to use his property as he was doing when this action was filed. He had to move the fence back.
Thank you very much. Mr. Strammel?
Yes, thank you, May it please the court.
Yes, it's now your time to address your arguments both as appellee and cross appellant.
Right.
Go ahead.
Thank you, Your Honors. So, Your Honors, just as an overview here, as you know, the issue is in regards to this disputed tract of land. It was our position that the Dirks were entitled to a prescriptive easement over that piece of ground. Now, we offered the district court a smorgasbord of different theories of recovery on that. We think that the evidence was sufficient to give the district court kind of the pick of the litter in terms of what it wanted to use in terms of granting us that access. The court found that there was a prescriptive easement, denied the remainder of the claims. Now, when Furches appealed the finding that there is a prescriptive easement, we went ahead and cross-appealed in regards to the denied claim. So our request today, Your Honors, is that the court affirm the district court with respect to that prescriptive easement. If the court would find that the prescriptive easement does not exist, then at that point in time, we ask that the court grant the same relief, just under one of the other alternative theories. In regards to kind of getting allowing the court to kind of get its feet underneath it in terms of what the court's looking at, Page City is unincorporated. It's a very, very small Northwest Kansas town. Per the testimony, there's maybe 10 houses in Page City, maybe 15 people who live there. I know that in the previous argument, there's various references to trails. That's all Page City has is trails. There are no paved roads. It's all graveled roads. And so that's a situation we're dealing with. And so
I've got a question for you, counsel, if you could.
yes.
front PCs, which they call a street here, is that maintained by the township?
Yes,
All right, so they bring the gravel in and they grade it and everything?
yes,
And
and
does the school bus come in there?
yes,
Does the school bus come into the loop?
yes,
Do
Yes.
ambulances come in and use the loop?
yes,
All of that is open now, due to the easement. Is that correct?
correct.
Now, if I'm looking at this correctly, the property line is, on the house on parcel 9, looks like it's right next to the end of the sidewalk. It looks like a little sidewalk there for that house. Is that the property line?
Yes,
And the garage, which is just north of it, is back a little bit from that, and there looks like a little bit of a driveway there. Is that correct?
I'm sorry, Your Honor, can you ask that last question again?
On the garage, there looks like a little bit of a driveway there, but it is set back from the property line a little more than the house is. Is that correct?
That is correct.
All right, so if you're using that garage, you're gonna be able to back your car up, but then you're gonna have to, if you're gonna stop at you're gonna have to really turn hard to get out of the garage to get out. Of course, you can't get out because there's not much access to front PC, is there? Because all of that is in the loop.
That's correct. There's no access.
There's really no access to use that roadway or trail or whatever you want to call it from that property line, is there?
That's correct.
Is that something that the judge seized upon?
Yes, the judge acknowledged that. I don't know if he actually said these words, but it's clear from that surveyor schematic that you're looking at with the red and blue and yellow lines that you cannot access this property. It is landlocked. And in fact, the property line goes over the end of that sidewalk. So I suppose you could pull a vehicle out of that garage and make a really hard turn, which, by the way, and so to answer one of your other judge's questions, when the salvage yard lies to the east of the home and garage. And so, in other words, just to kind of give your legs underneath you, the salvage yard is to the east, and then the garage then is to the north of the home.
Correct.
And so, yes, you could back out of that garage and make a really hard right turn to the north. You could drive right next to your front door over the sidewalk and over your grass, and then you would have to basically, I mean, there's no way then you would have to cross over the Furchess property to get to front PC, which the property not only is landlocked, but it's unusable without that circle loop that's disputed.
Let me ask you another question about that. That's all railroad right of way there? Used to be railroad right of way?
Yes, that's correct.
That's parallel. The one I'm looking at, you can see was that a co-op there?
Yes. So on the what would be to the south, where so front PC runs east and west, and so
Parallel to the
yes. So Highway 40. Yes,
Yeah.
and there's an elevator that you can just barely
Yeah.
see the edge of.
Yeah. Okay. Well, my question is, by custom and usage, that loop looks like it's been established for some time. Did the judge comment on that?
Yes, the testimony is that loop's been there forever.
Well,
What do you
this
mean?
used to be one tract of land, correct?
Yes.
When did it divide up?
The sheriff's sale, Your Honor, so the home was built prior to 1937. Then there is a sheriff's sale in 1937. And then the garage, and that's when the property divided. And then in 1947, that garage was built.
Okay. Well, that's, it was, one tract of land until the sheriff's deed, and that's when parcel 9 was created. Is that correct?
Your Honor, I'm not sure. I don't think parcel 9 was created then. I think it was still parcel 1 and parcel 9. It's just that it had common ownership.
All right, thank you. That's what I needed to know.
Okay, and could you explain to me that picture? I'm trying to see where it is. Volume 1, page 70. What the red out, I'm confused as to what that's supposed to be showing us.
Right. So, Your Honor, the on that surveyor schematic, there's some writing. I know it's hard to read, but all of these, and I don't know what copy Your Honor has.
I have whatever's in volume 1, page 70. It was
Right.
exhibit H to your petition, I think.
Well, and so what we had, Your Honor, at trial, the trial judge had some kind of a flash drive or something with the actual schematic on it, and then we had a large demonstrative exhibit where we kind of blew it up and used the pointer and pointed at things. So I'm just saying that unless you have that original flash drive or whatever that the court had, some of that wording is really hard to read. But to answer your question, the red that you're looking at, those are the boundaries of the parcels. And so you can see that the red line runs over just the edge of that sidewalk going north and south. That's a property line, and it
I
can.
think I'm sorry to interrupt, but I think you were talking about two different images. Judge Arnold is talking about, you're talking about the photograph, the aerial photograph, Judge Arnoldberger?
Yes, it's an aerial photograph.
Right, exhibit H.
It shows the house, it shows the salvage yard, and there's some kind of red boundary around it that I'm assuming must be significant or it wouldn't be attached to your petition. And I'm just trying to figure out what it is.
And it doesn't really show a loop so much either.
Yeah, it doesn't show much of the loop, but it's the stuff on the south. I don't understand what blocking off that little piece on the south. Is that supposed to mean that they could expand there? If they want to expand, they could expand to that point. They don't have to expand further west. Is that what you're trying to say?
I think I see what you're looking at, Your Honor. The aerial photograph with what looks like a thick red hand-drawn in line, that is a line. Yes. Yes. Okay. So that is a line, and I think that there should be testimony in the record on that. But that is a line that my client just drew in to show where she was and the predecessors and interest were maintaining that property.
Okay. All right. And so looking at that same photo then, his desire is to move that red line that's going north and south, to expand over into that loop so that there could not be the people coming in and circling around and coming back. They'd have to do the maneuver that you've talked about of backing out or pulling in or backing in, whatever, but they don't have that same kind of access. Am I right? Is he trying to expand it to the west?
Yes, he did expand that to the west, Your Honor. And in terms
That's the fence he put up.
Yeah, so what you're looking at in the photo you're referencing, that's the old line, and then
how far over did that fence go looking at that picture? Is it half of that? Did it come, was it half of that space or more than
I'd
half
say
of
it,
the space?
yeah, so in that surveyor schematic, which was exhibit P1 at trial, that has the actual foot dimensions marked, so you can see down to the foot how far over it went. But to answer your question, it was roughly half of that.
Okay, thank you.
And
That helps me.
okay, and then also to comment on your question as well, it's been difficult to know what Mr. Furch's position is. He moved the fence over. He didn't move it all the way to the property line, but he basically said, "This is my property. Nobody's going to be on it." But then at trial, he said, well, he thought that there should be a 30-foot easement there past the property line. And so it's just, quite frankly,
Mr. Strammel, can I ask you, was the fence approximately, I'm looking now at the P1 surveyor schematic, was the fence approximately 30 feet from the property line? Because the property line is way up at the house. If we can all agree that would be impossible for them to access. So the fence, did he put it up 30 feet from the property line?
you were kind of cutting out. Can you ask that again? I'm sorry.
All right, was the fence approximately 30 feet from the property line?
The fence as it was relocated.
Right.
I apologize. The copy that I've got on my computer here, I'm looking at, I can't make out the foot that's mentioned
So,
on.
can I ask, is the relocation of the fence the green with the X's?
Would you,
Yes.
Judge Her,
Oh no, I lost you. Sorry, go ahead, Judge Arnoldberger.
whoops. Would you mind telling me what exhibit you're looking at so I can be looking at the same thing?
Absolutely. It's labeled P1 surveyor.
Where is it in the record? What page?
And that's, oh, it's under the exhibits in the
Okay.
record.
Okay.
Sorry.
Thank you. I'm just trying to look at the same thing.
Yeah. So is the green line with the X's, is that where the fence was relocated to?
Yeah, that should denote yes. Yes.
Okay. And so when I look at this picture, there's this then yellow lines with the dots on it that shows like a presumptive pathway to the garage. Do you see that?
Yes.
So why is that insufficient?
Well, Your Honor, I believe that the reasonableness argument is applicable to a couple of the claims that were denied, specifically.
Like, let's say there's an easement. Let's say there's an implied easement by necessity. Would this yellow portion be sufficient in that? Would that be okay? Why not?
We don't think it would be, simply, Your Honor, because it does not allow vehicles to circle in and out. I mean, it's one thing to inconvenience. Well, okay, so first of all, that's not been a historical use. The historical use and the benefit of that property has been that you have ease of ingress and egress, meaning you can drive in, you can park, you can circle around, and you can exit. If you look at that.
Understand, come on, we're talking about an area where you said 15 people live. So my guess is that we're not picking houses based on ease of ingress and egress, right? So I understand it would be easier to loop around and to drive on someone else's property to loop around. I would love it if I could do that in my own driveway. But why is this not reasonable?
Well, Your Honor, if you have, say, two people living there, if you have any guess, I don't know how people get in and out.
Like if you lived in a cul-de-sac in Johnson County, there's nowhere to park in the edges. Everybody has to park in your driveway. I mean,
They may park in the driveway, but at least they can circle through the cul-de-sac and exit. And in this particular matter, it's a bottleneck where nobody can do that. Also, in terms of a school bus, a traditional use has been a school bus has gone through there. You take a long school bus, you just simply can't do it. I mean, heaven forbid there be a fire or an ambulance. I don't know how a fire truck is supposed to go in there and make a 3-point turn. Uh, it's not been a historical use, and it severely infringes upon the beneficial use of that property.
Can I ask a question that, so it is your position, that really whether what the defendant is claiming is reasonable or not is really irrelevant. There's either an easement or there's not. And
That's
the question is, what's the scope of that? What was that easement? Not
Precisely.
can someone, not that can someone change an easement because they want to increase their property. If there's an easement, it seems like it either is or it isn't. You don't get to adjust it later.
Correct.
Yeah. Okay. So your position is reasonableness really doesn't, although you do believe it's unreasonable to do it, reasonableness doesn't factor into whether there's an easement or not.
That's exactly right.
I had one more question. Earlier you testified that, or earlier you'd said that there was testimony that the property had always been used this way. But I am curious about the testimony prior to the purchase before. So the sort of 1970s, 80s testimony. Who established that, how the property was used during that time?
Individuals who were kids at the time. They rode the school bus. They visited the children who lived at the home at the time, as well as children who had grown and had lived there at the time. Testified that that's how it's been done, with school buses, with friends coming over, with the people who lived there maintaining the property. They sprayed weeds, they mowed, etc.
I don't have any more questions. Does the panel have anything?
Nothing for me, thank you.
Okay, Mr. Stramel, we asked you a lot of questions, but I'll give you just 30 seconds to wrap up if you would like. Could you address, if you do believe that there is a prescriptive easement, do you believe the court also needs to address your cross claims?
No, and that's just what I was going to close with. If the court affirms the prescriptive easement, there's no need to address any further cross claims. And we just ask that the court so affirm. And that's all I have. Thank you very much.
Thank you. Mr. Peckham, you have 4-minute rebuttal.
And before you get started, Mr. Peckham, I'd like to ask you the same question. What does reasonableness of this easement have to do with it? Isn't it that just there's either an easement or there's not?
I think there's some reasonableness doesn't, I mean, he said they could get in and get out going up the property line. And it's not really a question of whether or not it's, would be more reasonable to use somebody else's property to get easier access.
No, I'm not talking about easier access. I'm talking about, I think your client is saying, I want to extend my property line, and that's not affecting your easement because you're still going to have ingress and egress. Is that right?
That is correct, because he was not going to push it all the way over and make it difficult where she had to go over the
But
paper.
didn't he admit there was an easement?
what he said that he gave her permission to use the west side of his property to access her garage and so on. I mean, he gave her permission, which means it can be withdrawn at any time. But yeah, he did give her permission. And he also testified he went over to give the new owner, permission in 2022. And that's when things disintegrated. But
So is it the contention that the permission wasn't for as large of an easement as they took?
his contention is, he had given them permission to use the west side to access the garage. But that was, basically used as a driveway rather than have to, go over the grass right in front of the house.
Okay, that's the only question I have. You can go ahead.
Okay, basically, I'd like to point out a couple of things. One of the witnesses, Sean Plummer, who was a fire chief EMS member for 30 years, indicated that he had no problem using the driveway. In fact, he talked about turning ambulances around in the roads. It wasn't unusual. Also, there was a witness, Collins, who did some work for Moore's, who testified that she drove in her garage and then backed out. She did not use this large area in front of the house. She just went up the west line. And we would note that on an implied easement, I believe it needs to be a strict necessity. And Mr. Strom has admitted you can, going up through your own private access to garage. It's not the most convenient, but you can do it. Also, we seem to forget that the access to Mr. Furch's property comes off the railroad easement, and the Morris property is on that easement as well. So they're both basically in the same position in terms of accessing through the railroad easement. It's not a true landlocked situation. So we would just basically ask that the district court's granting of the prescriptive easement be overturned, and that Furch's be allowed to move the fence back to where he had relocated it.
So that picture with the yellow line going up to First PC, that's the railroad easement?
The railroad goes around.
It goes north and south?
Yeah, it's on the south side of both properties.
On the south side of it.
Yeah.
Okay, so the picture and exhibit on page 65, that's not the railroad easement. The railroad easement is the one that goes along the side of the property.
Yes.
Okay. Okay, thank you.
I would have nothing further.
Thank you very much, counsel, for presenting your cases so eloquently, and also for having such patience with us as we try to decipher your exhibits. We appreciate it. We, as you know, have reviewed the case thoroughly, and we will work on it and get back to you as soon as we are complete. So we appreciate your time, and with that,